Consider the following statements. The One Nation, One Ration Card scheme is aimed at enabling only the migrant workers and not their family members to buy subsidized ration from any fair price shop anywhere in the country under the National Food Security Act. This statement is wrong because not only a migrant worker, also the family members are eligible under this scheme. So statement 1 is incorrect. The centre has set the implementation of One Nation, One Ration Card as a precondition for additional borrowing by states. If the states want to borrow additionally, one condition, one requirement for that is, if you have implemented One Nation, One Ration Card scheme, the states are allowed to borrow additional money, borrow additionally. This is one condition. So statement is correct. Non-NFSA, which is Non-National Food Security Act ration card holders, which is the ration card issued by the state government, they are also covered under One Nation, One Ration Card. No. I've told you the state governments, they have also issued ration cards, but they do not come under One Nation, One Ration Card scheme. That is why states such as West Bengal wanted that we will implement this One Nation, One Ration Card scheme, but you should also allow the ration cards issued by us to be covered under this One Nation, One Ration Card scheme. But the central government did not agree, so statement 1 and 3 are incorrect. The question is asking which of the following statements are correct. B, only 2 is the right answer. Let's look at another question. Consider the following statements regarding One Nation, One Ration Card scheme. And it talks about these two portals that we discussed. Integrated Management Public Distribution System portal and Anna Vitran portal. Anna Vitran portal maintains a record of interstate transactions. No, it maintains a record of intrastate, inter-district transactions. The Integrated Management of PDS portal records the intrastate transactions. Basically, I have interchanged the options. They record interstate transactions. Which of the above statements is or are correct? D. None of these statements are correct. D is the right answer. Let's look at something else. Which of the following statements regarding urban local bodies or urban local body reforms is or are correct? If you look at urban local bodies, they have the power to impose property tax. They also have the power to charge user fee, which is users will be charged based on their consumption of water, based on their utility of various other schemes. So these urban local bodies, they have the power to impose taxes, property tax. They also have the power, the provision to charge users for the services that they are availing. The Ministry of Finance, Department of Expenditure under the Ministry of Finance, it has set conditions. What is this condition? Normally, 3% of global or gross state domestic product. What is the GSDP of a particular state? 3% of that could have been borrowed by the states. This was the condition. Finance Ministry said, we will increase this borrowing by 2%. That means the states will be allowed to borrow additional 2% of their gross state domestic product. But this 2% additional borrowing will be conditional. Conditional in the sense, 1% of this 2%, the state would be in a position to raise provided the states implement some reforms. And one such reform was urban local body reform. What is this reform? The urban local bodies should be in a position to impose this property tax, periodically revise this property tax as well, to impose these user charges and periodically revise them, so that through this revenue is generated by urban local bodies, so that they become financially independent as well, so that they are able to raise additional revenue, because of which they will provide services to the people. So 2% additional borrowing is allowed for a state, but it is conditional. And the conditional is 1% of it you can borrow as a state, provided you have implemented such reforms. One such reform is urban local bodies reforms. Which are these other reforms? Implementation of One Nation, One Ration Card, If you implement that, then we are able to provide you additional 2% borrowing through open market operations. Ease of doing business reform, urban local body or utility reforms. Utility, for example, drainage system that you are using, for that user service charges will be imposed, and also the power sector reforms. Let's look at the question, because urban local bodies, they are also part of Indian polity. If we look at Panchayati Raj institutions, they are primarily implemented in every single village in this country, which is a directive principle of state policy. Constitution says that the state shall endeavor to establish Panchayati Raj institutions and empower them with powers so as to enable them as units of rural local self-government. 73rd Amendment of the Constitution in 1992 provided a constitutional status to Panchayati Raj institutions, and 74th Amendment provided constitutional status to urban local bodies. It is part of your Indian polity. Let's look at the question. Which of the following statements regarding the urban local bodies reforms is or are correct? These reforms are stipulated by the Department of Expenditure, Ministry of Finance. I told you this is correct. The states implementing the reforms become eligible to mobilize additional financial resources through open market borrowings, something that we have discussed. Goa is the only state to complete such reforms. No. Kerala has implemented these reforms. Andhra Pradesh has, Tamil Nadu has, Telangana has, Madhya Pradesh has, Rajasthan has, Manipur has, Goa has. So Goa is not the only state to complete such reforms. So 1 and 2 are correct. A is the right answer. Let's look at another question. With respect to the functioning of the parliament, consider the following statements. There was a ruckus during the recently concluded monsoon session of the Indian Parliament, and ultimately 8 members of the Rajya Sabha, they were suspended. It is in this backdrop that I have picked this question. Number 1, the presiding officer of both the houses can order the removal of a misbehaving member in their respective houses. Yes, the marshals will be called, and those who misbehave. Now, what is misbehavior here? If you are raising placards, that's misbehavior. If you're shouting slogans, that's misbehavior. If you're entering into the well of the parliament, well of the house, that's also misbehavior. If you're snatching the bills, if you're snatching the documents, tearing them away, throwing microphone at each other, destroying the property of the house, it all comes under misbehavior. And the presiding officer of both the houses, they have the power, they have the provision ordering the removal of these misbehaving members. Statement 2, both speaker and the chairman can suspend a member in their respective house. This statement is incorrect. Why? Because speaker does have the power to suspend a misbehaving member, to suspend a member who has misbehaved in Lok Sabha. But chairman does not have this power. This is a very important statement. Chairman does not have the power to suspend a member of the parliament belonging to Rajya Sabha. What he has to do, he has to put this proposal before the Rajya Sabha. If Rajya Sabha members pass a resolution, then these misbehaving MPs of Rajya Sabha will be suspended. So Speaker of Lok Sabha can suspend a misbehaving MP, but the chairperson of Rajya Sabha, he cannot suspend. He can order the removal of these misbehaving MPs, but he cannot suspend. Suspension has to be done based on the resolution passed by Rajya Sabha. Chairman does not have that power. So statement 2 is incorrect. A member of the House can't be suspended for a period exceeding the remainder of the session. This is correct. Which of the above statements is or are correct? Presiding officer has the power to order the removal of misbehaving MP. Yes. Both speaker and chairman can suspend a member in their respective house. Speaker has that power, the chairman does not. So statement 2 is incorrect. A member of the house can't be suspended for a period exceeding the remainder of the session. This statement is also correct. So 1 and 3 are correct. C is the right answer. Let's look at another question. Which of the following statement is or are correct? What is the backdrop? We had Mr. Tirat Singh Rawat, who was till recently the Chief Minister of the state of Uttarakhand. And at the same time, he was also an MP belonging to Lok Sabha. Mr. Tirat Singh Rawat, he was appointed as the Chief Minister of the state of Uttarakhand. He was at the same time member of Lok Sabha. He did not resign from Lok Sabha. He assumed the charge of the Chief Ministership of Uttarakhand. After a few months, he was asked to resign. He resigned, and now he continues to be the member of the Lok Sabha of the Parliament. Is it constitutional that one person is occupying two posts at the same time? Constitution is absolutely clear that a same individual cannot be occupying two posts at the same time. So did Mr. Rawat violate the constitution because he was the member of the Lok Sabha and at the same time he was the Chief Minister of Uttarakhand? No, he did not. Why? Because you can be appointed as a Chief Minister, you can be appointed as a minister in a state, even if you are not a member of the Legislative Assembly, provided within 6 months you are getting yourself elected to either the Legislative Assembly or the Legislative Council. In Uttarakhand, we only have Legislative Assembly. So Mr. Rawat had 6 months before he could have got himself elected to the Legislative Assembly, and then he had to resign from Lok Sabha. That means he did not violate the constitution because he was occupying only one post, which is that of the member of the Lok Sabha. Once he is elected as an MLA, then he cannot hold two offices at the same time. But there are some critics who say morality dictates that somebody who is a member of the Parliament, before he is appointed as the Chief Minister or a minister in a particular state, he should resign from Lok Sabha. But that is part of morality, that's not part of the constitution, because Mr. Rawat did nothing wrong in not resigning from Lok Sabha and continuing as the Chief Minister for a few months. It is in this backdrop that let's look at these questions. Consider the following statements and which of these statements is or are correct. Number one, if a person is elected to both the houses of the Parliament, he must intimate within 10 days in which house he desires to serve, else his seat in Rajya Sabha becomes vacant. This is absolutely correct. If an individual has been elected to both the houses of the Parliament, he has 10 days to decide which house he wants to serve. Otherwise, his seat in Rajya Sabha would fall vacant. Statement 2, if a sitting member of one house is elected to another house, he must intimate within 6 months which house he desires to serve, else his seat in the first house becomes vacant. Absolutely wrong. If a member of one house, for example Lok Sabha, is also elected to another house, which is Rajya Sabha, that means I am already a member of the Lok Sabha. Now I have contested Rajya Sabha election and now I have got elected as the member of Rajya Sabha as well. Immediately, my first seat falls vacant. That means I don't have to wait for 6 months. Immediately, if the member of a house is also elected to another house, his seat in the first house becomes vacant. You don't have to wait for 6 months. That's why statement 2 is incorrect. A person elected to both the Parliament and the state legislature must intimate within 14 days. So you have to be absolutely clear regarding the time period. It is 10 days in one case, it is 14 days in another case, in which house he desires to serve, else his seat in Parliament becomes vacant. This statement is correct. 1 and 3 is correct. The question is asking which of the following statements are correct. B is the right answer. So here you have to look at number of days, 10 days in one case, 14 days in another case. You also have to focus on which seat falls vacant. Rajya Sabha seat falls vacant. Seat in the first house falls vacant. Seat in the Parliament becomes vacant. You have to be absolutely clear about these permutations and combinations. Very important question, can be expected in your prelims 2021. Staying with Lok Sabha, let's look at another question. Which of the following is or are the special powers of the Speaker of Lok Sabha? The Speaker has a special power, and that is certification of a bill as a money bill. Under Article 110, a money bill, after it is transmitted or before it's transmitted to Rajya Sabha, it is attached with a certificate by the Speaker that this particular bill is a money bill. Constitution itself says that this certification of a bill as a money bill by the Speaker is final. That's what Constitution says. But if you remember, when Aadhaar bill was passed by the Parliament, it was passed by both Lok Sabha as well as Rajya Sabha as a money bill. Matter went to the court. Jairam Ramesh, a Congress politician, approached the court and challenged the decision of the Speaker certifying Aadhaar bill as a money bill, and the matter is still pending before the court. So although the Speaker's decision certifying a bill as a money bill is final according to the Constitution, but since judicial review is also part of the basic structure of Indian Constitution, even this decision by the Speaker can be challenged in the courts. And you would know that insofar as a money bill is concerned, there is a very inferior role played by Rajya Sabha. A money bill can be introduced only in Lok Sabha, that too with the prior permission of the President of India, with the prior consent of the President of India. If money bill is introduced in Lok Sabha, it should be passed by simple majority. If it is passed by simple majority, the bill is transported to the Rajya Sabha. Rajya Sabha cannot reject a money bill. That's not the power available with Rajya Sabha. Rajya Sabha cannot also amend a money bill. That's not the power available with Rajya Sabha. Rajya Sabha can only suggest recommendations, or Rajya Sabha may not act on this money bill for 14 days. If these recommendations are acceptable to Lok Sabha, the bill is passed. If these recommendations are not acceptable to Lok Sabha, even then the bill is passed. If Rajya Sabha does not act on this money bill for a period of 14 days, after the 14-day period is over, this money bill shall be deemed to have been passed by both houses of the Indian Parliament. That means Rajya Sabha has a very inferior role when it comes to a money bill. So Speaker of the Lok Sabha has a power, has a special power. Under Article 110, the Speaker certifies a bill as a money bill, and the Constitution says that certification is final. So this is a special powers. Number 2, disqualification of members for violating the 10th schedule of the Constitution. Yes, this is also a special power that is available with the Speaker of the Lok Sabha. He has that power. Appointment of chairpersons of all parliamentary committees of the Lok Sabha. This is also the power available with the Speaker of Lok Sabha. So ideally, D, all of the above is the right answer. But this is where it can become tricky as well. When we say which of the following are special powers of the Speaker of Lok Sabha, special powers, that means when we say special, that means this power is exclusively available to whom? To the Speaker of Lok Sabha. But the chairperson of Rajya Sabha also has the power to disqualify an MP under anti-defection law. Same is the power available with the Speaker of the Legislative Assembly, with the chairperson of the Legislative Council. So this statement too, although it is a power of the Speaker of the Lok Sabha, but it is not a special power. If the question is asking a special power, then the ideal answer should be 1 and 3, C is the right answer. That means you have to be absolutely sure what the question is asking. If the question is asking for a special power, that means you have to look at exclusively those powers which are available with the Speaker. Similarly, chairperson of Rajya Sabha also has the power to nominate members to the parliamentary committees. But there can be instances where chairpersons can be elected as well. So when it comes to the chairperson of Rajya Sabha, he does not have that special power to nominate all the chairpersons of the parliamentary committees. That is why the answer is C, 1 and 3 is the right answer. Let's look at Deputy Speaker, because yesterday we discussed that we don't have a Deputy Speaker of Lok Sabha. The office of the Deputy Speaker of Lok Sabha is vacant. In fact, there is a public interest litigation pending before the Delhi High Court asking why we don't have a Deputy Speaker of Lok Sabha. Because it is mandatory under the Constitution to have Deputy Speaker of Lok Sabha. In fact, the election of the Deputy Speaker would be conducted on that date as may be fixed by the Speaker of the Lok Sabha. So it is mandatory to have the Deputy Speaker. Let's focus on Deputy Speaker, and you tell me what is the answer to this question. Whenever the Deputy Speaker of Lok Sabha is appointed a member of a parliamentary committee, he automatically becomes its chairman. This is absolutely correct because this is a privilege which is available to the Deputy Speaker of Lok Sabha. Whenever Deputy Speaker of Lok Sabha is appointed to a committee of the parliament, he invariably becomes the chairperson of that committee. That's the privilege available with the Deputy Speaker. So statement 1 is correct. Statement 2, the salary of the Deputy Speaker of Lok Sabha is charged on the Consolidated Fund of India. This is also correct. Which of the above statements is or are correct? C. Both 1 and 2 are correct. To ensure that there is independence given to some constitutional functionaries, that some constitutional functionaries are in a position to function independently without any threat, without any coercion, without any control by the legislature or by the government of the day, their salaries are charged on the Consolidated Fund of India. That means Parliament cannot vote on this expenditure, but Parliament can only discuss expenditures which are charged on the Consolidated Fund of India. For example, the salaries and allowances of the President of India, the Speaker of Lok Sabha, the Deputy Speaker of Lok Sabha, the Chairperson of Rajya Sabha, the Deputy Chairperson of Rajya Sabha, Comptroller and Auditor General of India, similarly the judges of the Supreme Court, the pensions of High Court judges, they are also charged on the Consolidated Fund of India. That means these expenditures are not subject to the vote of the Parliament, although Parliament can discuss such expenditure. This is just to ensure independence of these constitutional functionaries. So you have to be absolutely sure that if Deputy Speaker is in the news, you have to know everything related to Deputy Speaker. His salary is charged on the Consolidated Fund of India. C. Both 1 and 2 is the right answer. Let's look at another question. Recently, there was a cabinet expansion. More and more ministers were appointed to the Union Council of Ministers. And who gets which ministry? That's the prerogative of the Honorable Prime Minister. Constitution says the Prime Minister shall be appointed by the President. And all ministers shall be appointed by the President, but only on the aid and advice of the Prime Minister. So Council of Ministers are appointed by the President only on the aid and advice of the Prime Minister. What is the question asking? The maximum size of the Council of Ministers is determined by the Prime Minister. No, this is incorrect. Why? Because maximum size of the Council of Ministers is determined by the Constitution itself. How? We have 91st Constitutional Amendment Act, which was passed by the Parliament during the Prime Ministership of Mr. Atal Bihari Vajpayee. And because of this constitutional amendment, the strength of the Council of Ministers, the maximum strength, has been prescribed in the Constitution. Constitution says the size of Prime Minister and his Council of Ministers shall not exceed 15% of Lok Sabha. What is going to be the maximum size of the Council of Ministers? The size of the Council of Ministers, including the Prime Minister. So you may be asked in your examination, the size of the Council of Ministers, excluding the Prime Minister, shall not exceed 15% of the Lok Sabha. No, the size of the Council of Ministers, including the Prime Minister, shall not exceed 15% of the Lok Sabha. So the maximum strength of Council of Ministers is not determined by the Prime Minister. It's determined by the Constitution when it was amended because of 91st Constitutional Amendment Act in the year 2003. But yes, who gets which ministry is the prerogative of the Prime Minister. The Council of Ministers is responsible only to Lok Sabha. This statement is correct. Which of the above statements is or are correct? B, only 2 is the right answer. Council of Ministers collectively are accountable and responsible to Lok Sabha, and this is what we call parliamentary democracy. Parliamentary democracy ensures that Council of Ministers are collectively accountable to Lok Sabha. They swim and sink together, because if the Prime Minister resigns, that's the death of the entire cabinet. Something which happened yesterday. The Chief Minister of Gujarat resigned. Now only the Chief Minister is resigning. What happens to the other Council of Ministers? What happens to the entire Council of Ministers? It is assumed that the entire Council of Ministers, they have also resigned, because the resignation of a Chief Minister or a Prime Minister means the resignation of the entire Council of Ministers. The death of the Prime Minister or a Chief Minister means the death of the entire Council of Ministers, because they swim and sink together. Collectively, they are responsible to Lok Sabha, but individually, Council of Ministers collectively are responsible to Lok Sabha, but individually they are responsible to the President of India. And this is what we call the doctrine of pleasure. That means the Council of Ministers, they remain in office as long as they enjoy the pleasure of the President, which basically means the pleasure of the Prime Minister. Let's look at another question. Which of the following is correct regarding pre-legislative consultation policy, or PLCP, which was introduced in the year 2014? What is the context? 3 farm laws were passed, which we will discuss today very briefly. There is a lot of controversy surrounding these farm laws. Some people allege that the farmers were not consulted before passing such laws. So how can laws which are basically meant for the betterment of the people, betterment of the society, why don't you include the stakeholders, those for whom you are passing the laws? Why don't you include them? Why don't you discuss with them? That is what we call pre-legislative consultation policy. This was a letter, a notification was issued by the Ministry of Law and Justice in 2014 that we should follow pre-legislative consultation policy. That means whenever a draft bill is ready, the ministry should publish this draft bill on the internet, on website, and seek public opinion, so that we can include and involve public into the law-making exercise as well, because primarily the law is for the people. So let's include the stakeholders as well. Let's discuss with them. Let's seek opinions from them. Let's seek solutions from them. Let's seek their objections, so that we can make this law better, foolproof, for the betterment of the society. That is why some people allege that this pre-legislative consultation policy was not followed when the government enacted the 3 farm bills, presented the 3 farm bills, and Parliament passed these 3 farm bills without much discussion. So what is correct regarding pre-legislative consultation policy, or PLCP? It's a process through which the citizens engage with the government by providing feedback and comments on policies and draft bills. Keep that in mind, can be important potential question for your prelims 2021. Let's look at another question. Which of the following is or are now special powers available with Lok Sabha? Which are these special powers? Number 1, adjournment motion can be introduced only in Lok Sabha. Correct? You cannot introduce confidence motion, no confidence motion, censure motion, adjournment motion in Rajya Sabha. Why? Parliamentary democracy. Because Council of Ministers are collectively accountable to Lok Sabha. That is why adjournment motion can be introduced only and only in Lok Sabha, and if this adjournment motion is passed by Lok Sabha by simple majority, it amounts to censure of Council of Ministers. Clear? So this is a special power of Lok Sabha. A special session can be convened to disapprove the continuation of national emergency in Lok Sabha. This is something which was introduced by 44th Constitutional Amendment Act. The year was 1978. Article 352, Clause 8 was introduced. What is this clause? If 50 MPs of Lok Sabha, they write to the Speaker of Lok Sabha, if Lok Sabha is in session, listen to me carefully, if Lok Sabha is in session, more than 50 MPs write to the Speaker that we want a discussion on national emergency. If Lok Sabha is not in session, then 50 MPs will write to the President of India that we want a discussion on national emergency. And within 14 days, there has to be a discussion on national emergency. And then the Lok Sabha will decide whether we will approve national emergency or we will disapprove national emergency. So the continuation of national emergency, whether it should be allowed or disallowed, for that a special power is given to the Lok Sabha by Article 352, Clause 8, which was introduced into the Constitution by 44th Constitutional Amendment Act 1978. This is the power not available to Rajya Sabha. This is an exclusive power available with Lok Sabha. That's why it is a special power of Lok Sabha. Statement is correct. A constitutional amendment bill shall have to be introduced first in the Lok Sabha. This is wrong. Why? Because a constitutional amendment bill can be introduced in either Lok Sabha or Rajya Sabha. First in Lok Sabha, then in Rajya Sabha, or first in Rajya Sabha, then in Lok Sabha. This is not a special power available with Lok Sabha. Which of the following statements is or are correct? B, 1 and 2 is the right answer. Let's look at another question. We've had Rajya Sabha elections recently. In that backdrop, let's look at this question related to the election to Rajya Sabha. Which of the following statements is or are correct regarding the Rajya Sabha elections? Number 1, voters have the option of choosing nota. What is nota? None of the above. The year was 2013 when the Supreme Court asked the Election Commission of India that if people, they're not engaging with the system, we see that people disengage with the system, they don't come in large numbers and participate in the electoral process, participate in the voting exercises. So one way of bringing people into the electoral system is to provide them an option called nota, none of the above. So your electronic voting machine, the last button on an electronic voting machine should be nota. People are not participating in the electoral process because they think that all these candidates set up by the political parties, they are not worthy of our vote. Why should we vote for them? That's why they disengage from the system. Supreme Court said in 2013 that their Election Commission of India provide an option, nota, none of the above. On your electronic voting machine, the last button should be none of the above, nota, so that if citizens of this country, the voters of this country, they want to express their displeasure regarding the candidates set up by the political parties, they should have the option not to choose anybody, they can choose nota. But what if, for example, there are 10 candidates. Candidate 1 got 10,000 votes, candidate B got 9,000 votes, nota got 11,000 votes. Who is going to be the representative of this constituency? Not nota, but the candidate who gets the second highest number of votes after nota. Matter went to the court. The Supreme Court was asked, the dear Supreme Court, if in a particular election, highest number of votes are polled in favor of nota, then please do one thing, order the fresh election in that constituency. Because majority of the people, they are not satisfied with the kind of candidates put up by the political parties. That is why they have expressed displeasure. That is why majority of them have voted in favor of nota. Supreme Court said, no, we can't do that. Why? Because elections are costly in India. Elections are costly. It's going to be a huge burden on the state exchequer. It's going to drain our resources. That is why, if nota has got the maximum number of votes, who is the next person in line? That person is going to be your representative. We cannot hold fresh election if the maximum votes are polled in favor of nota. Also, matter went to the court. What about the Rajya Sabha elections? Supreme Court said voters have no option of choosing nota when it comes to a Rajya Sabha election. You don't have that option. Nota option is for Lok Sabha, Legislative Assembly elections, it's not for Rajya Sabha elections. Not voting for the party candidate will attract disqualification under anti-defection law. What do you think? Is the statement correct or incorrect? Whip, which is a 3-line whip issued by the political party to its members. If this 3-line whip is violated by the candidate, if this 3-line whip is violated by the member of your political party, you can be disqualified under anti-defection law. But this whip is not binding when it comes to the Rajya Sabha election, which means if your party is telling that vote for your candidate whom we have set up for these Rajya Sabha elections, if you don't vote for that candidate, you vote for someone else, which means cross voting has taken place. You are from BJP but you're voting for Congress, which is rare. You're from Congress, you're voting for the BJP, which is normal. You won't be disqualified. So anti-defection law will not apply in this case. Not voting for the party candidate will attract disqualification under anti-defection law. This is not correct. A member can vote in a Rajya Sabha election even before taking oath as a legislator. What do you think? Correct or incorrect? This is correct. A member, I've been elected as the MLA because MLAs have the power to vote in the Rajya Sabha elections. I'm elected as an MLA, but I am yet not taking oath. I have not yet taken oath as the MLA of a legislative assembly, but I am a legislator, which means I'm eligible to vote in the Rajya Sabha elections. A member can vote in Rajya Sabha election even before taking oath as a legislator. Slightly tricky, but can be asked in your examination. What is the question asking? Which of the following statements is or are correct? Only 3 is correct. C is the right answer. Now let's look at something else, and this is very important question because of some recent developments. Chhattisgarh, I think, is the state. One woman filed a petition before the court that her husband has forcibly had sexual intercourse with her, and that is why he should be punished for marital rape. One important statement: marital rape was sought to be criminalized. According to the recommendation of Justice J.S. Verma Committee, I think it was December 16, 2012, fateful night, when one physiotherapy student was moving along with her friend and she was gang raped, brutally gang raped in a moving bus, and ultimately she passed away at a hospital in Singapore. Nirbhaya, I'm talking about. It led to a wave of protests in different parts of this country. Ultimately, the government had to listen to the voices on the streets, and ultimately a committee was formed headed by former Chief Justice of India, Justice J.S. Verma. Justice J.S. Verma Committee recommended series of measures so that we can safeguard, protect the dignity of women in this country. That's led to a series of amendments in criminal justice system in India, that led to series of amendments in IPC as well. Justice J.S. Verma Committee had also recommended criminalizing marital rape. What is rape? Sexual intercourse without consent. But in marriage, the law assumes that there is always consent. So there is no concept of marital rape when it comes to India. But rape is rape, whether in marriage or outside marriage. Justice J.S. Verma Committee recommended criminalization of marital rape, but it has not happened. That's number 1. Number 2, the court in Chhattisgarh dismissed the petition of the petitioner, of the woman who alleged that she was raped against her wish by her husband. She wanted to punish her husband for marital rape. The court said marital rape as a concept is something that we do not recognize. That's number 1. Number 2, she also said that her husband has violated her dignity and has tried to do unnatural sex with her. She has violated her dignity by using objects, and through these objects he has ravaged her dignity. The court said, yes, this is something that we can punish your husband for because it comes under Section 377 of Indian Penal Code. What is Section 377 of Indian Penal Code? It criminalizes all those activities which are against, this is a very important question, listen to me carefully, against the order of nature. Whoever voluntarily has carnal intercourse against the order of nature, that is an unnatural offense, and that is criminalized under section 377 of Indian Penal Code. This particular section was particularly targeted at the members of LGBTQ community, lesbians, gays, bisexuals, transgenders, queers. In a landmark judgment in Navtej Singh Johar versus Union of India 2018, the Supreme Court said section 377 is read down. Read down in the sense, section 377, listen to me carefully, insofar as it criminalizes adult, consensual, sexual activity between two adults, whether of same sex or different sex, doesn't matter. This is not a crime. So homosexuality was decriminalized in 2018 in Navtej Singh Johar versus Union of India 2018. But section 377 was read down. That means section 377 still continues. Still continues. But section 377, insofar as it criminalizes the consensual adult sexual activity between two adults, it's not valid. That means homosexuality is allowed. But it is still valid if you are committing incest, bestiality. Sex with animals is a crime because it's an unnatural sex. It's an unnatural offense. It's against the order of nature under section 377 of the Indian Penal Code. This woman who alleged that her husband ravaged her, used objects to disallow her dignity, he can still be prosecuted because he has indulged in unnatural sex, which is against the order of nature, which comes under section 377 of Indian Penal Code. That's the difference. Section 377 has been read down. Homosexuality is constitutional. It's no longer a crime. But incest, bestiality, those offenses which are against the order of nature, they are still covered under section 377. So section 377 in its entirety has not been declared unconstitutional. Only insofar as it deals with the adult consensual activity, it's no longer a crime. Look at the question. According to the Indian Penal Code, sexual intercourse with a wife against her consent above the age of 16 is not rape. Is it 16 or is it 18? What do you think? I'll give you 2 seconds. 1, 2. Yes? No? Indian Penal Code says if the wife is 16 or above, it means that consent is always there in the marriage, which means sex with your wife, even against her consent, if the wife is 16 years or above, it's no longer a crime, it is not rape. If the wife is less than 16, it's a rape. Later on, Supreme Court, the judiciary said that the interpretation is that it is not 16, it should be 18. But that is the judicial interpretation. Judiciary says that sexual intercourse with a wife who is less than 18 years of age, against her consent, it is rape and you will be punished for that. But that is the judicial interpretation. The law is same. The law still says, IPC still talks about 16 as the age. That means the age of consent in a marriage is 16 years. So according to Indian Penal Code, sexual intercourse with a wife against her consent above the age of 16 is not rape, because according to Indian Penal Code, if it was according to the judiciary, according to the existing provision, then 18 should be the age. Section 377 of Indian Penal Code in its entirety was declared unconstitutional by the Supreme Court in Navtej Singh Johar versus Union of India 2018 case. Not in its entirety, because bestiality is still a crime. Incest is still a crime. There are some offenses which are against the order of nature, something that the wife of this husband was talking about. So in its entirety, it was not declared unconstitutional. 2 statement is incorrect. Which of the above statements is or are correct? A, only 1 is the right answer. Now let's look at something else. Mission Karma Yogi deals with, although we don't have much information about this scheme It has not been properly implemented yet, but just keep an idea. What is this mission Karma Yogi all about? It is basically a post-recruitment training mechanism of the officers and employees at all levels. Post-recruitment training mechanism of the officers and employees at all levels, state level, central level. That is Mission Karma Yogi. Clear? Let's look at another question. Section 321 of Criminal Procedure Code. This was in the news and I'll tell you how. Section 321 of CRPC, it gives power to public prosecutor. Public prosecutor, the government lawyer. Public prosecutor can approach a court and call for withdrawal of a case. If the withdrawal of this case is in public interest. I'll give you one hypothetical situation. Why hypothetical? This is something that happened in Punjab. Punjab, the employees of the Punjab state, they were protesting. They were protesting because they wanted increase in the salary many years ago. They also led to vandalization. They also destroyed public property. Cases were filed against them because you have destroyed public property. But then there was a compromise between the state government and the employees. Employees decided that, okay, we will withdraw our agitation because you have accepted majority of our demands. But the cases were filed against those who instigated these protests. Cases were filed against those who destroyed public property. Now, on one hand, we have had a compromise with the employees, and on the other hand, we cannot proceed with those employees who have led to the destruction of the public property because now there's a compromise. The public prosecutor approaches the court and calls for the withdrawal of this case because it is in public interest, because now we have sorted the differences. This is Section 321 of Criminal Procedure Code. But what is the link with our discussion today? According to various reports, one report given by Association for Democratic Reforms, which deals with electoral system in this country, which wants to reform the electoral system of India, it says that there are close to 4,969, or should we say more than 4,900 MLAs, MPs, legislators in this country against whom criminal charges are present. For the lack of a better word, we can say that there are 4,900, more than 4,900 criminals present in different houses of state legislatures and in the parliament. But something has happened. Karnataka, for example, recently approached the court, the public prosecutor approached a local court and decided to withdraw cases, and majority of these cases were against MLAs. Uttarakhand, for example, the public prosecutor of Uttarakhand approached a local court and asked for the withdrawal of a case against an MLA who was accused of murder. There are newspaper reports which suggest that Uttar Pradesh is also doing along the same lines, is also thinking along the same lines, asking the public prosecutor to approach the court so that we can withdraw the cases against MLAs. What's the context? 2020, September 2020, the Supreme Court in its judgment said, let's have special benches. Special benches which will try all those legislators and ex-legislators who are accused of criminal charges. So we have to speed up the criminal charges or the cases of criminal charges against the legislators and the former legislators. For that, special benches should be constituted. And these special benches will also monitor the progress made regarding the criminal cases which are pending against these legislators and former legislators. Ultimately, when the court saw this, that in Karnataka something is happening, in Uttarakhand something is happening, the court said, public prosecutor, yes, he has the power to approach the court to ask for the withdrawal of a case if it is in larger public interest, but If this case deals with MLAs, deals with legislators, then you can't approach a local court, you have to approach instead a high court. Long story short, public prosecutor has the power to approach the court, although we say this public prosecutor's power should be exercised by himself or by herself. There should be no political interference in this. But we know how the things function. These things are dictated by the expediency of politics also, most of the times. But normally we say public prosecutor applies his or her own judicial mind, approaches the court, calls for the withdrawal of a case. This is still the power available with the public prosecutor under section 321 of the Criminal Procedure Code. But when it comes to a legislator, public prosecutor, if it wants to approach the court asking for the withdrawal of a case against a legislator, for that you don't have to approach a local court, you don't have to approach a district court, you don't have to approach a metropolitan court, you have to necessarily seek the permission of a high court. So high court's nod, high court's consent is necessary before the public prosecutor applies for the withdrawal of the case against a legislator. This is in the news, can be potential statement for your prelims examination. Now let's look at something else. Which of the following is not a fundamental right? Very simple question. I hope all of you would be in a position to answer. So answer then. Which among the following is not a fundamental right? Right to privacy. It is a fundamental right under Article 21 of the Constitution. In a landmark 9-judge bench, the Supreme Court in K.S. Puttaswamy, who was the retired High Court judge, he approached the court because of Aadhaar and approached the court and said right to privacy is a fundamental right. A 9-judge bench of the Supreme Court was set up, and this 9-judge bench unanimously, by the majority of 9:0, all the 9 judges said right to privacy is indeed a fundamental right under Article 21 of the Constitution. Right to access the internet is also a fundamental right, not right to internet. Right to access the internet is a fundamental right. Right to carry on trade using the internet is a fundamental right. And right to marry the person of one's choice is also a fundamental right under Article 21. This was reiterated by the Supreme Court in the Hadia case as well, if you would know what that case is all about. But what is not a fundamental right? Right to reservation for anybody, whether members belonging to SC or ST or OBC community or economically weaker sections of the society, right to reservation is not a fundamental right. Right to reservation, if it's not a fundamental right, that means it is at the discretion of the state. If the state wants to provide reservation, yes. If the state does not want to provide reservation, even better. That's what the court has said, not me. Let's look at another question, fundamental duties. What is the context? The Delhi government has now decided to come up with something called Desh Bhakti curriculum to make students, the citizens, patriotic. That's one of the objectives of fundamental duties as well. Fundamental duties were originally not part of the Constitution. Prime Minister Indira Gandhi was in power. She asked her Foreign Affairs Minister, External Affairs Minister, Sardar Swaran Singh, that please come up with a list of fundamental duties that we can incorporate into our Constitution. Indira Gandhi was asked, Srimati Indira Gandhi was asked, what is the need to have fundamental duties mentioned in the Constitution? She said, people are aware of their fundamental rights. I want to make them aware of their fundamental duties as well. So fundamental duties, originally they were not part of the Constitution. They were added to the Constitution by 42nd Constitutional Amendment Act 1976. Initially there were 10 fundamental duties added, but later on, because of 86th Constitutional Amendment Act 2002, one more fundamental duty was added. So in total we have 11 fundamental duties mentioned under Part 4 capital A of the Constitution, dealing with Article 51 capital A. But all these fundamental duties, they are exclusively available to the citizens of India. They are not available to the foreigners. Japan is another country which has a list of fundamental duties prescribed. We have borrowed fundamental duties from the Constitution of the erstwhile USSR. That's something that can be relevant for your prelims examination. But listen to me carefully. When we say fundamental duty, there is something called mandamus. This was recently in the news, so you have to ensure that you link the topics as well. What is mandamus? If a public authority is not doing its duty, if a public authority is not doing its duty, what you can do? You can approach the Supreme Court under Article 32 of the Constitution and file a petition of mandamus. Listen to me carefully. If the public authority is not doing its duty, is it fundamental duty? No. Fundamental duties are not legal duties. That means fundamental duties are applicable for the citizens. But if there are citizens who are not abiding by these fundamental duties, you cannot approach the court and file the petition of mandamus, because these are not public duties. But yes, there are some fundamental duties which have been enforced through other laws passed by the Parliament. For example, one of the fundamental duty is abide by the Constitution, respect its ideal, national flag and the national anthem. And if you violate national anthem, you can be charged under Prevention of Insults to National Honor Act 1971. So there are some fundamental duties. Although Constitution has not prescribed any punishment for not following these fundamental duties or for violating these fundamental duties, Constitution has left the matter to the Parliament. If the Parliament wants to enforce some of these fundamental duties, and if you violate these fundamental duties, what punishment should be given to you, that's something that the Constitution has left to the Parliament. So fundamental duties, for example, to abide by the Constitution, respect its ideals, national flag and the national anthem. Another fundamental duty is to cherish the ideals which shaped our struggle for freedom. As a citizen, I have the fundamental duty to uphold the unity, integrity, sovereignty of this nation. I have the fundamental duty to render national service when called upon to do so. I have the fundamental duty to promote brotherhood and to renounce the practices which are derogatory for the dignity of the woman. I have the fundamental duty to develop scientific temper, spirit of humanism, reform. We have 11 set of fundamental duties. Let's look at the question. With reference to the fundamental duties provided in the Indian Constitution, consider the following statements. Fundamental duties were not part of the original Constitution, but all were added later by 42nd Amendment Act 1976. No, not all. 10 were added by 42nd Amendment. 11th one was added by the 86th Constitutional Amendment Act in the year 2002. So all were not added. Statement 1 is incorrect. They were added on the basis of the recommendation of Balwant Rai Mehta Committee. No. They were added on the basis of the recommendations of the Sardar Swaran Singh Committee. Balwant Rai Ji Mehta Committee was set up on, I know this is where you will make a mistake. Balwant Rai Ji Mehta was not set up on Panchayati Raj institutions. That's what you were thinking. Balwant Rai Ji Mehta Committee was set up to review Community Development Program of 1952, National Extension Service of 1953. So Balwant Rai Ji Mehta Committee was set up to review the progress made under the Community Development Programs and the National Extension Service. But this Balwant Rai Ji Mehta Committee recommended something called democratic decentralization. And this democratic decentralization later on led to the enactment of Panchayati Raj institutions, the start of the Panchayati Raj institutions. This recommendation was put before NDC, National Development Council, in 1958, and ultimately on 2nd October 1959, to mark the occasion of the Gandhi Jayanti, the first Panchayati Raj institution was established in a village in Rajasthan called Nagaur. Nagaur district of Rajasthan, the first Panchayati Raj institution was established. So Balwant Rai Ji Mehta committee recommended democratic decentralization, recommended that we should have a 3-tier Panchayati Raj system in place. But it did not recommend, it was not set up on Panchayati Raj institutions. It was set up to review the community development programs and national extension service. Fundamental duties, statement 3, are only applicable to Indian citizens and not to foreigners. This statement is correct. Which of the above statements is or are correct? C, 3 only is the right answer. Correct? Let's look at something else. The state can impose reasonable restrictions on the freedom of religion on which of the following grounds? What's the context? So-called love jihad or anti-love jihad laws passed by states such as Gujarat, UP and others. Can there be restriction on freedom of religion? Article 25, for example, which gives twofold fundamental right to every single resident of India. This fundamental right is not only applicable to the citizens, it's applicable to the aliens as well, to the foreigners as well. Freedom of conscience and freedom to profess, practice and propagate one's own religion. But this fundamental right is not absolute. The state can impose reasonable restrictions. On what grounds can the reasonable restrictions be imposed by the state on your freedom of religion? One is public order. The other is morality. The other is health. For example, during COVID-19 pandemic, temples, gurdwaras, churches, mosques, they were closed. Can the state interfere in the practice of religion for all the residents of India? Can the reasonable restrictions be imposed? Yes, in the interest of the health. Also, listen to me carefully. Constitution says subject to public order, morality and health. And other provisions of this part. Which is this part? We're talking about part 3 of the Constitution, which deals with fundamental rights. Article 25 says, subject to public order, morality, health, and other provisions of this part, which is part 3 of the Constitution, the state can impose reasonable restrictions on your freedom of religion under Article 25 of the Constitution. So which of the above statements are correct? D, all of the above is the right answer. Let's look at something else. Consider the following statements. Statement number 1. Any amendment to the citizenship law needs to be passed by the Parliament with a special majority. Statement 2. The central government may waive the conditions for naturalization in case of a person who has rendered distinguished service. Every naturalized citizen must take an oath of allegiance to the government of India. In India, a naturalized citizen cannot become the president or the prime minister of the country. Which of the above given statements is or are incorrect? Part 2 of the Constitution deals with citizenship. And in this part, we have articles dealing with 5 to 11. Articles 5, 6, 7, 8, 9, 10, primarily they talk about who is the citizen of India on 26 January 1950 when the Constitution was enacted, what happens to those who migrated to Pakistan and want to come back, what happened to those who want to come back from Pakistan or who migrated from Pakistan, so on and so forth. Article 11 gives power to the Parliament that you can regulate all matters related to citizenship. That means one important thing that you have to keep in mind, Constitution of India does not talk about little details, minute details regarding who can be the citizen of India, how the citizenship can be revoked, what are the conditions that you need to follow in order to become the citizen of India. Constitution has given this power to the Parliament under Article 11 of the Constitution, that dear Parliament, you can regulate all matters related to citizenship. And that is how in 1955 the Parliament of India enacted Indian Citizenship Act. And this Indian Citizenship Act has been amended multiple times, as recent as 2019, because CAA is basically an amendment of Indian Citizenship Act. But Citizenship Act is basically an ordinary law. And an ordinary law, in order to be passed, in order to be modified, requires what type of majority? Simple majority. So any amendment to the citizenship law needs to be passed by the Parliament with a special majority. This is wrong. Why? Because you only require simple majority. Clear? Statement 2. The central government may waive the conditions for naturalization in case of a person who has rendered distinguished service. Naturalization. One way in which you can become citizen of India. But there are some conditions that you have to follow. Conditions such as you should have stayed in India for 11 years. Conditions such as you should have the knowledge of any language, which is mentioned under Schedule 8 of the Constitution. Another condition is you should make your intention clear that you want to make India your permanent home. Another condition is you should renounce your previous citizenship, because you cannot hold dual citizenship at the same time. Another condition is you should not be from a country where Indians are not allowed to become Indian citizens. So there are lots and lots of conditions that you have to follow in order to become Indian citizen through naturalization. For example, John Drays, for example, Mother Teresa, for example, Adnan Sami. They became citizens of India through naturalization. But central government and one ministry which is responsible for the citizenship is MHA, Ministry of Home Affairs. MHA can waive all these conditions if you have rendered distinguished service in the field of art, in the field of literatures, social service, world peace, human progress, art. In all these matters, if you have rendered distinguished service, then all these conditions can be waived. All these conditions in the sense, even if you don't know any language mentioned in the 8th schedule, that's okay. Even if you have not resided in India for 11 years, even if you are from a country where Indians are not allowed to become citizens, but one condition which cannot be waived is that you have to renounce your previous citizenship. You cannot hold dual citizenship. That's something that we do not allow. But do you know, there is one group of people, only one group of people who is allowed dual citizenship. Do you know of this group? Here is a couple, an Indian couple, or let's say the parent, one of the parent is an Indian. The child is born outside India. That means here is a child who is born to an Indian parent, not on the soil of India, but the child is born outside the territory of India, let's say United States. And in United States, they follow a practice called Jus Soli, which is law of the soil. Anybody who is born on the soil of United States is the US citizen. But in India, we follow the concept of Jus Sanguinii, which is law of the blood. So even if you are not born on the soil of India, but by blood you are related to an Indian, no matter where you are born, you are still an Indian. Now look at this. Imagine a situation where we have a child. The child is born on the soil of United States. By Jus Soli, the child is a US citizen. But at the same time, this child is an Indian citizen because this child's parent is an Indian. This condition is the only way in which this child has dual citizenship. So this child, born outside of the territory of India to an Indian parent, enjoys dual citizenship. But only till the child attains the age of 18. Once the child attains the age of 18, the child has, now he's not the child, he or she has 6 months to decide whether you want to continue as the citizen of that country or you want to retain the citizenship of India. But that means till the age of 18, this particular individual who was born outside the territory of India, he enjoys dual citizenship. Otherwise, India does not recognize dual citizenship. So the central government may waive the conditions for naturalization in case of a person who has rendered distinguished service. This is correct. Every naturalized citizen must take an oath of allegiance to the government of India. Not to the government of India, to the Constitution of India. So statement 3 is also correct. Incorrect. In India, a naturalized citizen cannot become the president or the prime minister of the country. This is wrong. Although, okay, let's not get into that, but this is wrong. This is not correct. The Constitution only says you should be a citizen of India to become an MP, to become an MLA, to become the Prime Minister, to become the President of India. So it doesn't say that you should be a citizen by birth or descent or naturalization or registration, only a citizen. So even a naturalized citizen is eligible to become the Prime Minister or the President. What is the question asking? Which of the above given statements is or are incorrect? 1 is incorrect, 3 is incorrect, 4 is incorrect. A is the right answer. Let's look at something else. With reference to election symbols, consider the following statements. This is something which has been in the news in the past. Mr. Tirat Paswan, the son of the late Union Minister Ramvilas Paswan, he was in a sense thrown out of his political party. His uncle did something of a coup. He captured his political party and ultimately he also became a union minister in the recently conducted cabinet reshuffle. But be that as it may, there is a dispute and Mr. Chirag Paswan now wants to retain the symbol of his political party. This happened when AIDMK got split after the death, unfortunate death of J. Jayalalitha. It got split into the two factions, one led by TTV Dinakaran, the other led by Palaniswamy and Paneer Selvam. Be that as it may, the question was who gets the two leaves symbol of AIADMK. So election symbol, very important. What's the question? With reference to the election symbols, consider the following statements. Number 1, no two political parties can have the same election symbol. What do you think? No two political parties can have the same election symbol. What do you think? Right or wrong? No two political parties can have the same election symbol is wrong. Look at TDP of Chandrababu Naidu. What is the symbol? Cycle. What is the symbol of the Samajwadi Party led by Akhilesh Yadav? Cycle. What is the symbol of National Panthers Party of Jammu? Cycle. So two political parties can have same symbol as well, which means if, for example, Samajwadi Party wants to contest elections in Andhra Pradesh, Samajwadi Party candidates will not be given cycle symbol. They have to choose another symbol. Or Telugu Desam Party wants to contest elections in UP, but in UP, which is the recognized state political party, Samajwadi Party, which is not recognized as a state political party, Telugu Desam Party. So Telugu Desam Party, if it wants to contest elections in Uttar Pradesh, they may not get to use their own election symbol, they have to choose another election symbol. But two political parties can have the same symbol in India. I have given you examples as well. So statement 1 is incorrect. After a split in a political party, the Supreme Court has the power to decide which faction of a political party gets to use the allotted symbol. No, this is the power to resolve, to adjudicate this dispute. This is not with the Supreme Court, it lies with the Election Commission of India. So which of the above statements is or are correct? None. Neither 1 nor 2. Political parties can have same symbol as well. After a split, Election Commission gets to decide. Correct? Are these tough questions or easier? Let me know in the comment section that today these were tough questions or very easy. It's just like a cakewalk. I'm going to clear prelims. All my best wishes. Which of the following statements is or are correct? Number 1, appointment to the office. Is polity interesting? If yes, let me know by liking this video so that I can get to know how many amongst you feel that polity is interesting. Okay, I'll check. It's 1.5 thousand right now, number of likes. After 2 minutes, I'll have a look at the number of likes again and see if you like this subject. I like this subject. Now let's look at the question without wasting time. Which of the following statements, why I'm wasting your time is, in a sense, today is the last class. And I will get to see you again after the crash course is over. So we'll be taking newspaper analysis, we'll be taking the explained sessions as well. So I'll miss you. So that's why I'm initiating some sort of conversation with you. But leave that aside, let's not waste your time. Which of the following statements is or are correct? Number one, appointment to the office of the Chief Justice of India should be of a senior most judge of the Supreme Court considered fit to hold the office. Statement 2, whenever there is any doubt about the fitness of the senior most judge to hold the office of the Chief Justice of India, the President shall seek the opinion of the Parliament before making any appointment. India is perhaps the only country in the world where judges are appointed by themselves. Because of the judgment in the year 1993, which was known as the second judge's case, and the judgment in 1998, which is known as the third judge's case, and then we also have a fourth judge's case, which is known as 2015 NJAC judgment. We have a clear system of judicial appointments. And what is the system? You would know there is something called collegium system. So I will not explain how this system evolved, how this system functions. That is something that you would know. Who all are part of the collegium, that's something that you would know. But how do we appoint Chief Justice of India? Or who should be appointed? Who should be appointed as a judge of the Supreme Court? Who should be appointed as the judge of a high court? How can we proceed with the transfer of judges from one high court to another high court? All that is done by collegium. And for that we have something called MOP. What is MOP? Memorandum of Procedure. So when in 1993, Supreme Court arrogated the power, said now from now onwards, if there is any vacancy, we will initiate to fill this vacancy. We are going to tell you that these are the individuals that you have to appoint as the judges of the Supreme Court and the High Court. You don't have that power. So when in 1993 and afterwards, Supreme Court arrogated the power, snatched the power from the executive, India became the only country in the world where judges are appointed by themselves. But then judiciary and executive went into consultative mode and came up with memorandum of procedure. This memorandum of procedure was last updated after this NJAC verdict in the year 2016. So this procedure says, whenever a name is recommended by collegium to the president, to the government, you have to accept that name. Or you give us in written why you don't agree with that name. You give us in writing why are you objecting to this name which has been recommended by the collegium. And if we will reiterate, we will again insist on this name, it is practically binding on you. But as we have seen recently, for example, Justice Akil Qureshi, who was initially considered to be the Chief Justice of Gujarat High Court, but then he was transferred. And then he was all said to be appointed as the Chief Justice of Madhya Pradesh High Court, but instead he was shifted to Tripura as the Chief Justice of Tripura High Court. His rank is at serial number 2 in terms of seniority. He's the second most senior judge across the high courts in India. He was also, according to newspaper reports, recommended by the collegium to be appointed as the judge of the Supreme Court. But then the government did not agree. And the Supreme Court did not insist on this name. That is why, if you recall, during maybe this can be a statement in your prelims examination. During the Chief Justiceship of Justice Sharad Arvind Bobde, S.A. Bobde, no single appointment to the Supreme Court took place. And newspaper reports say that is precisely one reason that is attributed to this non-appointment is that Justice Rohinton Fali Nariman, who was part of this collegium system, according to newspaper reports, I'm not privy, he says he was insisting on the name of Justice Qureshi. So Justice Qureshi should be appointed to the Supreme Court. Till that time, we should not appoint anybody. So there was lack of consensus within the collegium. That is why during the Chief Justiceship of Justice Bobde, no appointment took place. Immediately once Justice Nariman retired, his term got over, Justice Ramana, along with other members of the collegium, remarkably appointed, recommended names to the Supreme Court. We have only one vacancy now in Supreme Court, just one vacancy. And we have also seen that 3 women judges were appointed. And in all likelihood, we are going to witness a first time a women Chief Justice of India in few years from now. Although she is going to have a very small tenure of 1 month or 1 month or so, but nevertheless it's significant. She's broken the glass ceiling. We are going to have for the first time a Chief Justice who is a woman of the Supreme Court. But be that as it may, what I'm saying is that this memorandum of procedure says who is going to be the Chief Justice of India. I am the Chief Justice of India. Before my term is about to get over, I will nominate my successor. And normally the successor is the senior most judge. Next to me, who is the senior most judge? I will nominate this person to the government, appoint this person as the Chief Justice of India, provided this person is fit to hold the office. If I consider that this person is fit to hold the office, I will recommend his name to the government. The government will appoint this person as the Chief Justice of India. So appointment to the office of the Chief Justice of India should be of senior most judge of the Supreme Court, considered fit to hold the office, yes. But what if I consider he is not the fit? Then President does not have to consult the opinion of the Parliament. President has to consult the opinion of other judges of the Supreme Court, the senior judges of the Supreme Court. Then the President will have to make an appointment, not the Parliament. So statement 2 is incorrect. The question is asking, which of the following statements is or are correct? A, only one is the right answer. Now let's look at something else, memorandum of procedure. In practice, consider the following statements regarding MOP followed for judicial appointments. In practice, if the collegium reiterates a recommendation, it is binding on the government. 2, it was last renegotiated by the executive and the judiciary in 2016. That's something I told you here. After NJAC judgment in 2016, this MOP was renegotiated because NJAC judgment, Supreme Court said by the majority of 4:1 that NJAC is unconstitutional. Why unconstitutional? Because NJAC violates independence of judiciary. NJAC violates primacy of Chief Justice of India in judicial appointments. And the Supreme Court said primacy of Chief Justice of India in judicial appointments is also part of the basic structure of Indian Constitution. That is why on these 2 grounds, 1, NJAC violates independence of judiciary, 2, NJAC violates another basic structure, which is the primacy of Chief Justice of India in judicial appointments. That's why NJAC is unconstitutional. There was only one judge who dissented, Justice Chalabeshwar, but we don't have to get into that. In 2016, this memorandum of procedure was renegotiated between the executive and the judiciary. So it was last renegotiated by the executive and the judiciary. Statement 1 is slightly tricky. Tricky in the sense, if the statement, listen to me carefully, if the statement would have mentioned, if collegium reiterates a recommendation according to memorandum of procedure, it is binding on the government. But what is it saying? It's saying in practice. Newspaper reports suggest, various newspaper reports, that there are many names recommended by the collegium twice. That means collegium recommends a name, recommended few names, the government sent the names back, collegium reiterated these names. In reality, it should have been binding on the government. The government could not have sit on these appointments, but the government has refused to appoint them, which means the government has decided that these names are not binding on us, despite the fact that you have reiterated these names. So in practice, if the collegium reiterates a recommendation, it is not binding on the government in practice, because the government has done that. It has sat on these names. It has rejected the names reiterated by the collegium. So in practice, if the collegium reiterates a recommendation, it is binding on the government. In practice, it is not true. So which of the above statements is or are correct? B, only 2 is the right answer. Let's look at something else. Consider the following statements, or which of the following statements is or are correct regarding National Legal Services Authority. But first up, I'll take a look at the number of. Very good. 800 more. Keep on liking. It won't take much of your time. Which of the following statements is or are correct regarding National Legal Services Authority, NLSA? The Chief Justice of India is the executive chairman of NLSA. No, not the Chief Justice. A senior judge, for example, Justice Ramanna, before he was appointed as the Chief Justice of India, he was a senior judge of the Supreme Court. He was the executive chairman of National Legal Services Authority. Chief Justice is not. So statement 1 is incorrect. The administrative expenses of this authority, National Legal Services Authority, including the salaries, allowances, pensions payable to the officers and other employees, shall be defrayed, shall be withdrawn out of the Consolidated Fund of India. Tricky question or difficult question, difficult statement, but this is correct. Their expenses are not charged on the Consolidated Fund of India, but drawn from the Consolidated Fund of India. That means an appropriation bill needs to be passed, and then you can withdraw money for these functionaries. The function of the authority is to encourage the settlement of disputes by way of negotiation, arbitration, and conciliation. This statement is also correct. Select the correct options from below. C, 2 and 3 is the right answer. Lok Adalat. Now, Lok Adalat, they have given sanction, they have been given status under Legal Services Authorities Act of 1986-87. So Lok Adalat is a forum where civil disputes are resolved. This dispute can either be pending in a court of law or this dispute yet to approach the court. Normally what happens, you and me have a dispute. I tell you I will see you in court, but the courts are overburdened with lots and lots of work. There are crores and crores of cases pending. More than 3.5 crore cases are pending across different courts in this country. Supreme Court, High Courts, various district courts in the country. District courts are more guilty of this pendency of the cases. When I say I'll see you in the court, I'm overburdening the court. Is there an alternative, or what we call alternate dispute resolution? Is there an alternate to dispute resolution? One such alternate is Lok Adalat. Lok Adalat will have a sitting or a retired judicial office, will have one lawyer, will have a social activist, and they will, through arbitration, resolve the disputes between you and me. But these disputes should be of civil nature. The only criminal case that a Lok Adalat can take up is a check bounce case. It's a criminal case. This is the case that Lok Adalats can take. Otherwise, they normally take up only the civil cases. But if there is a case which is pending in the court of law, and you and me want to resolve this dispute in a Lok Adalat, I will withdraw this case from here, and whatever fee I have paid, I will get that fee back as well. But even if this case is not yet in a court of law, even then I can approach the Lok Adalat. Clear? What's the question? Lok Adalat is a forum where only the disputes, cases which are pending in the court of law are settled or compromised amicably. Wrong. When we say only those disputes which are pending in the court of law, what about those disputes which have not yet reached the court of law? Those cases we can also file in Lok Adalat. So statement 1 is incorrect. Lok Adalat is an extra constitutional entity. That's correct, because Lok Adalat is not mentioned in the Constitution. Constitution only talks about Supreme Court. Constitution talks about High Courts. Constitution talks about district courts as well. So all these 3 courts are constitutional courts. But Lok Adalat is provided with a statutory recognition under the Legal Services Authorities Act 1986-87. So it's an extra constitutional entity. So statement 2 is correct, 1 is incorrect. Which of the above statements is or are correct? Only 2. B is the right answer. Correct? Let's look at something else. Staying with Lok Adalats, because massive Lok Adalats were conducted recently. National level Lok Adalats, very important question, keep that in mind, revise it multiple times, remember it, rote level memory. National level Lok Adalats are held at regular intervals, where on a single day, Lok Adalats are held throughout the country in all the courts, right from the Supreme Court till the taluk levels, wherein cases are disposed of in huge numbers. Lok Adalat held in Supreme Court or not, held in high courts or not, held at local levels or not, simultaneously at all the levels. Yes, this statement is correct. Lok Adalats, national level Lok Adalats are held at regular intervals, where on a single day across, cases in large numbers are disposed of. For example, motor vehicle insurance claims, other claims, they're disposed of. Since 2015, national Lok Adalats are being held on specific subject matter every month. This statement is also correct. Remember both these statements. Which of the above statements is or are correct? C, both 1 and 2 is the right answer. Let's look at Article 142 of the Constitution. Under Article 142, the Supreme Court can issue any order so as to provide complete justice. And this is something which was invoked by a 2-judge bench of the Supreme Court recently, last year, when Justice Rohinton Fali Nariman was one of the judges, and it was related to Mr. T. Sham Kumar. T. Sham Kumar was basically a Congress MLA. He resigned from the Congress party, joined the BJP. Basically should have been disqualified under anti-defection law. But instead he was made a minister. He was made a forests minister in the state of Manipur. Matter went to the court. The court is asked that this person should have been disqualified under anti-defection law. He is not disqualified. The court is giving a lot of time to the speaker. Take the decision, take the decision. The speaker is not taking the decision. Ultimately, the court said enough is enough. Rohinton Fali Nariman, Justice, issued order under Article 142 and removed that minister. Who appoints a minister? Governor. Who has the power to remove a minister? Governor. Who has removed a minister? The Supreme Court. How? Under Article 142. Under Article 142, Supreme Court can issue any order so as to give complete justice. It's an extraordinary plenary power. Plenary power, that means this power cannot be regulated by the executive. This power cannot be regulated by any other entity. Supreme Court's own power. T. Sham Kumar, he was removed as a minister and he was told, don't you dare enter the Legislative Assembly. And ultimately the speaker disqualified T. Sham Kumar from the Legislative Assembly under anti-defection law. The question is asking, under Article 142, which allows the Supreme Court to pass any order necessary to do complete justice in any case, has been invoked in which of the following cases? Union Carbide case, which happened in the 1980s when Mr. Arjun Singh was the Chief Minister of Madhya Pradesh. The leak which happened. Yes. Banning the sale of alcohol within a distance of 500 meters on national and state highways across the country so as to prevent traffic accidents. It was invoked during this case. Ram Janmabhoomi Babri Masjid land dispute. Yes. In all these cases, D is the right answer. Babri Masjid and Ram Janmabhoomi dispute case, primarily the court said this land belongs to Lord Ram. The government should set up a trust and take the steps for the construction of Ram temple at Ayodhya. What about Muslims? You have lost your mosque, you have lost your site where you would pray. So in order to give you complete justice, 5 acres of land at a prominent location in Ayodhya should be given by the state government to the Muslim Waqf board, wherein if they want, they can construct a mosque in order to provide complete justice to the Muslim community. So in all these cases, Article 142 was invoked. D is the right answer. Now let's look at CAG. A new CAG, Mr. Murmu, was appointed by the President of India. Mr. Murmu previously was also the first Lieutenant Governor of the Union Territory of Jammu and Kashmir, and prior to that he was also a senior IAS officer from the Gujarat cadre. The CAG shall not be eligible for further office either under the Government of India or the Government of any state after he has ceased to hold his office. this statement is correct. You cannot hold any office after your term is over, which is for 6 years. This CAG takes oath before entering his office to uphold the Constitution. Both these statements are correct. C is the right answer. There are some constitutional functionaries, for example, Vice President of India. He takes the oath that I will faithfully discharge the duties of my office. When it comes to the President of India, President takes the oath to defend the Constitution, to preserve, protect and defend the Constitution. That's the oath of the President. Dr. B.R. Ambedkar said the most important office under the Constitution is the office of CAG. And what is the oath? He takes the oath to uphold the Constitution. That's a very important thing, can be relevant for your prelims. Both these statements are correct. C is the right answer. Let's look at the 3 farm laws, and we will discuss strictly according to the requirements of your prelims examination. There is already a detailed video lecture available on our YouTube channel where I have discussed the 3 farm laws. You can go through that video lecture to understand, but very briefly. We have these 3 laws. What is law number 1? Law number 1 allows a farmer to sell his produce at a nearby APMC mandi or another APMC mandi of that state or another APMC mandi of a different state. So intrastate and interstate freedom for a farmer to sell his produce. That's law number 1. Law number 2, it provides a national framework for contract farming. So in match the following types of questions, this can be relevant for your examination. And then the third one is the Essential Commodities Amendment Act 2020, under which basically potatoes, onions, cereals, pulses, they have been withdrawn from Essential Commodities Act. Under Essential Commodities Act, basically, if the prices of commodities increase, for example, onions, Essential Services Act can be invoked, which means there is a limitation on the number of kgs of onions that you can stockpile. Beyond that, stock will be confiscated by the government. That's Essential Commodities Act, to keep a check on the prices. But the government said to popularize farming, to establish infrastructure, onions, potatoes, pulses, cereals, oil seeds, they will come out of Essential Commodities Act. What's the controversy then? We don't have to look into it. We just have to understand from polity. Agriculture is a state subject. Not just agriculture, trade and commerce within the state is part of state list. But if it is interstate trade and commerce, intrastate within the state, that's part of the state list. State has the power to regulate it. But if it is interstate, this is the power available with the parliament. Not just that, production, supply and distribution of goods is under the state list. Markets and fairs is under the state list. By looking at agriculture, if it is part of the state list, by looking at trade and commerce within the state, production, supply and distribution of goods, markets and fairs, all this is part of state list. By looking at this, we can safely assume that agriculture marketing is primarily within the domain of the states. The states have the power to regulate it. Then how is Parliament making a law? Is Parliament wrong in making these laws? Has the Parliament violated distribution of powers under Schedule 7 of the Constitution? No. Why? Because all this is subject to entry 33 of list 3, which is concurrent list. That means on all these matters, Parliament also has the power to make a law because it also comes under concurrent list. But this is something under Article 369 of the Constitution. Listen to me carefully. Under Article 369 of the Constitution, this power, where Parliament will keep a control over trade and commerce within the state, this power was vested with the Parliament under Article 369 of the Constitution only for a period of 5 years. That means from 1950 till 1955 only, Parliament had the power to regulate these agricultural matters. But what was temporary What was meant for only 5 years, that was made permanent when Constitution was amended by the Third Constitutional Amendment Act in 1954. So what was temporary, what was meant for only 5 years, that was made permanent for entire duration by Third Constitutional Amendment Act 1954. Long story short, agriculture, state list. Trade and commerce within the state, state list. Interstate trade and commerce under parliament, because that's part of the union list. But markets and fairs, production, distribution, supply of goods, although that is part of the state list, but that is subject to entry 33 of list 3, which is the concurrent list. But this was meant to be for a temporary period. This was meant to be only for a period of 5 years, from 1950 till 1955. But what was meant to be temporary, what was meant to be only for a period of 5 years, was made permanent when in 1954 Constitution was amended and Third Constitutional Amendment Act was passed. This is something that you have to keep in mind when it comes to the 3 farm laws. Let's look at another question. Consider the following statements regarding the National Human Rights Commission and select the correct option. NHRC is in the news because of the developments in West Bengal, because NHRC is also involved in taking a look at the post-poll violence or the alleged post-poll violence in West Bengal. What is NHRC? NHRC is basically a statutory body, and this statutory body was established in the year 1993 under the protection of Human Rights Act of 1993. Clear? This National Human Rights Commission, it consists of chairperson and other members. Clear? But this chairperson is appointed by the president based on the recommendation of a committee. So you may be asked about who is part of this committee to appoint the chairperson of National Human Rights Commission. Prime Minister is part of it. Union Home Minister is part of it. Leader of opposition in Lok Sabha is part of it. Leader of opposition in the Rajya Sabha is part of it. Speaker of Lok Sabha is part of it. The chairperson of Rajya Sabha is part of it. This committee recommends name to the president in order to be appointed as the chairperson of National Human Rights Commission. This act, which gives statutory backing to National Human Rights Commission, this was amended in 2019. Prior to 2019, this chairperson had to be an ex-Chief Justice of India. After 2019 amendment, the rules say, the act says, this person should be the judge or an ex-judge of a Supreme Court. Basically, prior to 2019, who could have been appointed as the chairperson of National Human Rights Commission? Somebody who was the Chief Justice of India, retired Chief Justice of India. Now 2019 amendment says this person, in order to be appointed as the chairperson of National Human Rights Commission, should be an ex-judge of the Supreme Court. And that is how Mr. Arun Mishra, Justice Arun Mishra, was also appointed this year as the chairperson of National Human Rights Commission. Mr. Arun Mishra once famously said that Prime Minister of India is a versatile genius. He thinks global but acts local. He's a genius. And he was appointed as the chairperson of National Human Rights Commission. Another change which happened in 2019, prior to 2019, reappointment was possible. That means a member of the National Human Rights Commission could have been re-nominated or reappointed for a term of 5 years. Listen to me carefully. Prior to 2019, the member of NHRC could have been reappointed, but for a period of 5 years. Now, 2019 amendment says reappointment, yes, but period 5 years, no. That means we will specify for how many years this person will be reappointed. The reappointment period of 5 years has been removed, but reappointment will still take place. One important thing, that you need to understand regarding NHRC is that every 5 years, NHRC has to come under accreditation. Very, very important statement. Accreditation such as our colleges and universities, which are accredited by the NAC, where some colleges are A+, some A, some A-, some B+. In a similar fashion, NHRC is also under accreditation after every 5 years. Last time it was done in 2017, but who does this accreditation? A United Nations special agency. And who is the special agency? Global Alliance of National Human Rights Institutions. Global Alliance of National Human Rights Institutions. And in 2017, our NHRC was given the status of A. That means it was ranked A in this accreditation by the GANHRI. And any national human rights agency which gets the status of A, it means that our NHRC, which will now become the decision maker of this global alliance, and will also participate in Human Rights Commission, United Nations Human Rights Commission, which means every 5 years, National Human Rights Commission is subject to accreditation by a United Nations specialized agency, which is Global Alliance of National Human Rights Institutions. In 2017, the last time when this accreditation was done, we were given the status of A, accreditation of A, which means any organization which gets A or above will be in a position to become the decision maker of this global alliance, and will also participate effectively, will also become a decision maker of United Nations Human Rights Commission. But on what grounds is this accreditation done? This global alliance basically checks whether this National Human Rights Commission follows or effectively notes the Paris Principles. If accreditation of National Human Rights Commission is done, on what grounds? We have to judge whether NHRC follows the 6 principles of Paris Principles. One principle is that mandate should be given to NHRC. It should be backed by a law so that it has the mandate to uphold the human rights of your country. Second, it should be autonomous of its functioning from the government. Third, it should be plural. Plural in the sense that means we should have a diversity in the composition of NHRC. That is why in 2019, when amendment was made, the law says at least one member of NHRC should be woman. So this is plural. 4, it should have its power to investigate. It should have resources. NHRC has the power to investigate into allegations of violations of human rights. That's the power available. And at the same time, it should be competent as well. That means these are the 6 Paris Principles. When accreditation of NHRC is done, it is done on the basis whether our NHRC follows in toto these 6 Paris Principles. And that is how it can get A or less than A in this accreditation. Let's look at the question. Consider the following statements regarding National Human Rights Commission and select the correct option. The chairperson of the NHRC is a person who has been a Chief Justice of the Supreme Court now. Has to be a judge of a Supreme Court because the changes were made in 2019. The Act does not allow for reappointment of the members of the NHRC. The Act does allow for reappointment, but it's only that previously the Act says reappointment for 5-year term. That 5-year term has now been removed, reappointment for any number of years, but reappointment is there. Which of the above statements are correct? D. None of these statements are correct. Let's look at another question. Which of the following statements is or are correct regarding the Competition Commission of India? Why? Because Competition Commission of India, which is a statutory body which was passed under the Competition Commission of India Act 2002. This act was amended in the year 2007. It is a body which ensures that there is solid competition. There should be no monopoly. For example, if tomorrow Airtel and Jio, they decide to merge with each other, it won't be allowed by Competition Commission of India, because then it will lead to monopoly. And when in any sector there is monopoly, there is no competition. And when there is no competition, who is at a disadvantage? The consumers, you and me. That's why, to ensure that competition is healthy, we have this Competition Commission of India. Let's look at the question. It was in the news recently because of various acquisitions that took place. It was in the news, that's why this question has been picked. CCI consists of a chairperson and 6 members appointed by the central government. Yes, it's the duty of the commission to protect the interests of consumers. This is where you might confuse yourself. The duty of CCI is to promote healthy competition or to protect the interests of the consumers. If you promote competition, if you ensure competition, which means you are protecting the interests of the consumers. Because if there is no competition, there is monopoly. Who is at a disadvantage? The consumer. That means it is the duty of the commission to protect the interests of the consumers. Which of the given statements are correct? Both. C, 1 and 2 is the right answer. Now, which of the following statements regarding electoral bonds is or are correct? Number 1, only recognized political parties can raise funds through electoral bonds. There are political parties which are registered, and there are political parties which are recognized. Recognized as state, recognized as national political parties. Any political party registered with the Election Commission of India, if it gets not less than 1% of the total votes in the recent election, whether it's a legislative assembly election or a Lok Sabha election or a general election, such a political party is empowered, is eligible to raise funds through these electoral bonds. So only recognized political parties? No. Any political party registered with the Election Commission of India which gets not less than 1% of the total votes is eligible to raise funds through electoral bonds. Statement 1 is incorrect. Electoral bonds cannot be purchased multiple times by the same applicant. Electoral bond scheme, one interesting detail, was made part of Finance Act in the year 2017. So it was announced in the Finance Act of 2017 when Mr. Arun Jaitley presented the budget, but it was implemented in the year 2018. Can be important for your examination. Why would government say that Mr. X can buy electoral bonds only once? You cannot buy these electoral bonds again. The government, the political parties would want more and more funds from the same person. So on the face of it, the statement looks incorrect. Electoral bonds cannot be purchased multiple times by the same applicant. Can be purchased multiple times, but you have to purchase in the form of 1,000 rupee, 10,000 rupee, 1 lakh rupee, 10 lakh rupee, 1 crore rupee, and you can purchase it multiple times. All you have to do is approach the State Bank of India. Once electoral bond is purchased, it cannot be cancelled and no amount will be refunded to the purchaser. This statement is correct. It cannot be cancelled. The electoral bond shall be valid for 15 days from the date of issue. Once I approach the State Bank of India, and these are basically bearer bonds, anonymous bonds, nobody gets to know who is donating to whom, only the political party will get to know. But if I approach the State Bank of India, buy an electoral bond worth 1 crore rupee, deposit it into the bank account of a particular political party, the political party has 15 days to withdraw the funds. After that, it will lapse. So this is correct. So which of the following statements are correct? 3 and 4 are correct. C is the right answer. Which of the following statements is or are correct? National and state parties can only field 30-star campaigners during election campaigns. Unrecognized political parties cannot field star campaigners during the election period. Who are these star campaigners? For example, Prime Minister, top ministers, they are declared as star campaigners by the BJP. Prior to COVID-19 pandemic, these national and state political parties, these recognized political parties, they could have nominated 40 star campaigners. But because of the COVID-19 pandemic, this has been reduced to 30. Clear? Unrecognized political parties could have also nominated star campaigners. Prior to COVID-19, the number was 20. They could have nominated 20 star campaigners. But now the number has been reduced to 15. So unrecognized political parties cannot field star campaigners during the election period. This is wrong. National and state parties can only field 30 star campaigners during the election campaign. This is correct. Which of the following statements are correct? A, only one is the right answer. What happens because of these star campaigners? There is a limit to the amount of money I can spend campaigning for my election. For example, if I'm campaigning if I'm a candidate contesting elections from Delhi to Delhi Legislative Assembly, I have the limit that I have to spend 28 lakh rupees. But if I bring in a star campaigner, his chopper fee, food, accommodation, others, that means I am spending the entire money in bringing the Prime Minister to campaign for me. This is where the idea of star campaigners come. These star campaigners, if they campaign, whatever money is spent on them will not be included in my election spending. But please understand this carefully. If I'm a star campaigner, you are the election candidate. You brought me that please campaign in my constituency. Whatever money is spent on me will not be included in your election campaign. But if you share stage with me, all expenses related to me will be added to your expense. If I take your name, all expenses related to me will be added to your campaign. If there is a poster which has my photo as well as your photo, all expenses related to my campaign will be merged with your expense. That means star campaigners, they campaign, but generally for a political party, not the candidate. If I take your name, if I ask people to vote for you, all the expenses that you have spent on me will be added to your election expense. That is something that you have to carefully take note of, star campaigners. Now let's look at Aadhaar. Unique Identification Authority of India possesses information about the caste and religion of the Aadhaar card holders. Aadhaar, which is a unique identification number, a 12-digit unique identification number, but it is only an identifier. I'll take 5 more minutes of your time. I know I'm running out of time. Just 5 minutes. Let's be done with these important questions and then you may leave. But those who want to leave, please stay. 12-digit unique identification number. Aadhaar is only an identifier. It is not a profiler. It does not profile people on the basis of religion, caste, so on and so forth. UIDAI possesses no information about the caste and religion of Aadhaar card holders. Statement is wrong. Employers can credit their contribution of the PF only if the employee's Aadhaar number is linked to the universal account number. September 2021. Employers also contribute to your provident fund. But now employers can contribute to your provident fund only if the employee's Aadhaar is linked with UAN. This statement is correct. Which of the above statements is or are correct? B, only 2 is the right answer. The Unique Identification Authority of India is a statutory authority established under the provisions of the Unique Identification Authority of India Act 2016. No, it is a statutory body but established under the Aadhaar Act, Aadhaar Targeted Delivery of Goods and Subsidies Act of 2016, not under UIDAIA Act. One of the mission of UIDAI is to provide for good governance. This is correct because good governance, because Aadhaar deals with the withdrawal from Consolidated Fund of India. If we withdraw money without any leakage, without any duplication, we are reaching the goal of good governance. So one of the objectives of UIDAI is to provide for good governance. Statement 1 is incorrect. Which of the following statements are above statements are correct? Only 2B is the right answer. Which of the following is correct regarding Blue Aadhaar? Blue Aadhaar is Aadhaar issued to children below the age of 5. Interesting thing, no biometric would be collected of these children. After 5 years are over, this Blue Aadhaar is invalid. And biometric of children above the age of 5 would be taken after 5 years and then 15 years. But before 5 years, no biometric information will be collected. So what is correct regarding Blue Aadhaar? Aadhaar issued to children below the age of 5. Model Code of Conduct was introduced by the Election Commission during the tenure of Chief Election Commissioner T.N. Seshan. No. It was effectively implemented, enforced by Mr. T.N. Seshan. But Model Code of Conduct has been in place since 1968. In fact, it started off in Kerala, then it started off in states such as Kerala, West Bengal, Tamil Nadu. In fact, Tamil Nadu had a standing committee of 7 members belonging to 7 model throughout implementation but it was amplified. It was root claims and addresses, and prior approval is required. Which of the following statements is correct about DPSP? The Constitution of India classifies DPSPs into social, liberal, intellectual and Gandhian principles. Constitution does not. Jurists, constitutional experts say some of these DPSPs reflect the values of Mahatma Gandhi, reflect liberal intellectual values, reflect the socialistic values. Constitution does not classify them into Gandhian, socialist or liberal intellectual principles. Dr. B.R. Ambedkar hailed DPSPs as the conscience of the Constitution. Not Dr. B.R. Ambedkar, Granville Austin said that these DPSPs are the conscience of the Constitution. They are non-justiciable in character, that means they are not enforceable in a court of law, and hence not cited by judiciary while deciding the constitutionality of a law. Yes, they are not justiciable in nature, but they are cited by the judiciary in various judgments. So this is also incorrect. The question is asking which of the following statements are correct. None of these statements are correct. D is the right answer. Now the last question, which of the following statements is incorrect regarding the concept of democratic decentralization in India? Democratic decentralization is a constitutional mandate. Correct. It's provided by Panchayati Raj institutions, 73rd Amendment. It facilitates greater participation of people in the decision-making process, which is correct. Gram Sabha. This process has helped in significantly reducing the level of corruption in India. It has not. It has helped to increase the participation of women in political process because there is reservation for women in Panchayati Raj institutions. The question is asking which of the following is incorrect. C is the right answer. That is it from our polity-based current affairs segment. I hope these lectures have been of some help to you. Please like this video, subscribe to our channel and attend the future classes, live classes targeting prelims 2021. And let me know in the comment section if these polity-based lectures have been of any help to you. I promise to go through all these comments and possibly reply to each one of you. Thank you for being with us. All the best for your exams. Don't stress. Treat this like any other exam. I'm sure you will qualify. Life will be meaningful for you. Thank you for staying with me all these days. Good night.